them we had some good news and some bad news and asked which they wanted first. Which do you want to hear first?
You're directing that question to me?
Yeah. Uh-huh.
I'm always one for bad news first, but, you know.
Okay, good. Okay, so from the year 6000 BC up into 1540 AD, approximately, there were only 500,000 laws worldwide. From around 1540 to around 1798, another 500,000 laws were added. But
so now we're up to...
What's that?
I said, so now we're up to 1 million.
Now we're up to 1 million. So 1798 to 1920, for some reasons that we'll explore in the future, another 10 million were added.
Oh, good.
And then from 1920 to 2019, so basically 100 years, more than 70 million statutes, codes, rules, agency, you know, they call them laws, they're nothing. 70 million more were added, so we're up to 80 million laws, and so the really bad news is that you're supposedly, as a citizen, you're supposedly responsible for following all those 80 million laws.
You know, I heard somewhere, and it's been a long time, this is probably even 10 years ago, that on average, every American citizen breaks 5 felonies every day or something crazy like that. You know, just by doing what we do, because we don't even know what all these laws are and what all these rules are, and we're just living our lives being good people and breaking rules all along the way. It's like putting a bunch of kindergartners in a seat and say, sit still for the next 8 hours. You know, next thing you know, half of them are on Ritalin.
Yeah, something like that. Yeah, and the really, truly bad news is that you'll hear code enforcers say, your ignorance of the law is no excuse. And
I love that word. It depends. It kind of reminds me of the word unalienable rights, because how you pronounce the word makes all the difference, because it can be unalienable and you think, you know, someone's not an alien, or unalienable, meaning that you can't put a lien against it. And then you take the word ignorance, right, and you could say ignorance means one thing, but ignorance is a totally different concept. So I guess it depends on how you pronounce that word, ignorance. I kind of like that pronunciation better.
Ignoring the laws is no excuse, but there is some good news that you can be lawfully excused from the 80 million laws. And that's one of the big purposes of what we're doing here, telling people about how it's the underpinning of why anybody would want to ever correct their status. And that's so that they can have knowledge of all the laws and fully be able to uphold them and enforce them. And I found something today that I thought you would really like. It's a decision in the civil system even. And it's United States versus Johnson. The privilege against self-incrimination is neither accorded to the passive resistant nor to the person who is ignorant of his right, nor to one indifferent thereto. It is a fighting clause. Its benefits can be retained only by sustained combat. It cannot be claimed by an attorney or solicitor. It is valid only when insisted upon by a belligerent claimant in person. The one who is persuaded by honeyed word or moral suasion to testify or to produce documents rather than make a last-ditch stand simply loses the protection. And this is talking directly about one of the particular articles in amendment, talking about the Fifth Amendment, but belligerent claimant in person. And that's what we as Americans need to be, but how are we going to be a belligerent claimant of our rights if we really don't know what they are? So that's a huge part of why we're talking about the Bill of Rights today.
And I know that the purpose of this conversation right now is not to talk about political status per se. There's other conversations and there's other people discussing that. I mean, I'm glad you brought it into the conversation, but I don't want it to get confusing for folks because it's not, at least that's not what I thought we were going to talk about today. But understanding that if you claim yourself as a citizen, then you are subject to these 80 million laws. And, you know, as Maria said, your ignorance or ignorance of them is irrelevant. And even if you don't know what they are. But, you know, figuring out how we can protect ourselves as citizens is what this Bill of Rights says. I mean, this Bill of Rights here is designed for citizens, correct?
No. That's the whole enchilada. You got it right there. No. So yeah, I'm like I was saying. So why don't I tell it how it is so that it's not confusing. Because it's easier just to tell, you know, basically talk about the straight up truth, and then we can go through and kind of ask questions later, because we want to give people the solid, you know, earth beneath their feet. We want them standing on solid ground. The Bill of Rights is declaratory of our common law, okay, and they come from the Bill of Rights comes out of the basically 1689 English Bill of Rights. John Adams, the colonial American law student, John Adams, Thomas Jefferson, and James Madison learned of the spirit of the common law behind Magna Carta through Edward Coke's volumes called the Institutes of the Laws of England. So these things these Bill of Rights came from somewhere. And a lot of people may not have heard of Edward Coke. Edward Coke was a judge, Sir Edward Coke, 1552 to 1634, an English judge and a common lawyer of renown, and a foremost champion of the common law's supremacy over kings. So basically what we have here is we have common law rights for the people. The Bills of Rights declare our common law, meaning the people's common law. And that is as opposed to, in Europe it was the king's law. In this country it was the law of the ruling class or of the state they were creating, the union of states they were creating. So the Bills of Rights are for the people. And the reason that we correct our status is because at some point later down the road, after the founding, the people were persuaded to go into another system where they gave their oath of fealty to a different system other than the common law system. And the reason I want to talk about this, too, is that there's lots of people out there talking about now de facto, what do you have to do to correct your status? And I don't hear very many people talking about where this law came from, what it is, how we got it, why the Bill of Rights is so important to us as each and every individual American. So I think first we need to understand, basically, you know, that's probably all you want to know about where it came from, 1689 English Bill of Rights, and that the founders, you know, thought it was important. At the Constitutional Convention, there was a lot of debate about whether or not we wanted to list what our rights were. And the states submitted hundreds of the rights that they thought needed to be memorialized in this Bill of Rights. And at some point, Madison whittled it down to and drafted 10 that seemed to cover everything. And then that Ninth Amendment that we read earlier, the Ninth Amendment that we talked about, reserved everything we didn't put down into the Bill of Rights. So that's a good start for people to understand where they derived from. And so what I thought we could do is just kind of go through today and read each one and then talk a little bit about the history of that. In regards to the fact that there's 80 million laws and whether or not we, the people, are responsible for learning all of those laws, I wanted to go back through this 1983 congressional statute. It's the 96 statute. It's Public Law 97-280. So you can look it up online just as 97-280, Public Law 97-280. It went through Congress by unanimous vote October 4th, 1982. And it's talking about making the 1983 the year of the Bible. And it says, whereas the Bible, the Word of God, has made a unique contribution in shaping the United States as a distinctive and blessed nation and people, whereas deeply held religious convictions springing from the Holy Scriptures led to an early settlement of our nation, and whereas biblical teachings inspired concepts of civil government that are contained in our Declaration of Independence and the Constitution for the United States, whereas many of our great national leaders, among them Presidents Washington, Jackson, Lincoln, and Wilson, paid tribute to the surpassing influence of the Bible in our country development. In the words of President Jackson, that the Bible is the rock on which our republic rests, whereas the history of our nation clearly illustrates the value of voluntarily applying the teachings of the Scriptures in the lives of individual families and societies, and whereas this nation now faces great challenges that will test this nation as it has never been tested before, whereas that renewing our knowledge and faith in God through Holy Scripture can strengthen us as a nation and a people, now therefore be it resolved that the Senate and the House of Representatives of the United States of America and Congress assembled, that the President is authorized and requested to designate 1983 as the National Year of the Bible in recognition of both the formative influence the Bible has been for our nation and our national need to study and apply the teachings of the Holy Scriptures. Now, I put that statute and that public law in direct conflict with this idea that we have to understand 80 million laws and that we're responsible for 80 million so-called laws. And the way that we can do that is just to look and see whether or not your private faith is that you believe the Bible, that you study the Bible as your private faith. What I would like people to understand is historically that the 1611 King James Version verbatim is what the oath of office commits to uphold. And so what I'm going to show you is how you learn only one law. And in learning only one law, you're upholding basically everything else you need to know in those 80 million. So one law replaces 80 million laws, is the thought. And the law is basically, it's the basis of common law, do no harm. Do all you've agreed to do under all of your contracts, but don't harm another. Don't cause a harm, an injury, or a loss to another. And if you do, you're responsible for making that neighbor of yours whole. And where we find that's biblical and why it's the cornerstone of our common law is that it says so in quite a few of the New Testament books. But somebody asked Jesus the Master, what's the greatest commandment? And he says, love the Lord thy God with all thy heart, with all thy soul, with all thy mind. And it's the greatest and first commandment. And the second is thou shalt love thy neighbor as thyself. So you wouldn't do something to yourself purposefully that would hurt yourself, harm yourself, cause yourself an injury, or cause yourself a financial loss, and that's the way you should also treat your neighbor. And so that's why I bring in this particular statute and bring in the laws, because the common law actually, we know, there's plenty of history that shows that we know that it was basically the outworking. It's the outworking of the totality of the 66 books that we know as the Bible. And so if we want to go back and think about the Mayflower Compact and when people first set foot on the land, and especially people that were coming from Europe and there were Reformation Christians who had just newly had the Bible transferred into a language they could understand, and it was no longer just being held by the priest to tell them what the interpretation was. They were going to, for themselves, read this book of their faith, and when they were able to do that, they wanted to live in accordance with it and have a government that was in accordance with it. So they came and started with the Mayflower Compact, and then gradually went into the Articles of Confederation, and then that morphed into the Constitutional Convention and became the basis of our law. I just want to read, I'm recommending this book to everybody. It is, if you want to look at the history, and if you want to understand common law versus civil law, this is the best reference I've ever seen. It's called Excellence of the Common Law. It's by Brent Allen Winters, and you can have a copy just by going to commonlawyer.com. So find this book on commonlawyer.com, and I'm looking at page 783. He says, the Constitution is among the briefest and clearest human expression of the controlling principles of common law and government available. The Supreme Court, you can see Chapter 3 and Chapter 5 in this book, for the Supreme Court's recognition that the Constitution expresses the language and principles of the common law. And so the Constitution expresses the common law, and the Bills of Rights are declaratory. Both the Federal Bill of Rights, which we're studying today, and the Bill of Rights in your state's Constitution, under the first article in most cases, that's the common law of our state. And when we were up there in Fairbanks the other night, I think it's really apparent that Americans understand what our common law is. We have it. It's just part of the fabric that we expect from our government. And so that's why we all kind of expect that this is the law citizens are entitled to. And you know, we can get into the nitty-gritty of that, but the bottom line is it absolutely is what all Americans are entitled to. It's the law that's written on our heart. They're people, I think, if they haven't studied it, and none of the gurus out there talking about status correction are talking about why you should correct your status. And the reason you should correct your status is because you volunteered into citizenship in the United States, and that's coming under a whole different perspective of law. That's coming under Roman civil law. You've agreed into Roman civil law, and you have forfeited your rights to the Bill of Rights by saying, I don't need the Bible. I don't need the foundational law. I need Roman civil law, and I'm happy to go over there with the Pope and do what he dictates I should do. So what we've come back to is that the whole thing's been obfuscated. It's been totally, the wool's been pulled over our eyes, and the Congress gives lip service to us as to which bills of rights we're allowed to have. And I think it's really important right now when Biden's talking about taking the guns, that people understand exactly where they are claiming their Second Amendment right from. I think this is timely. I think it's it has everything to do with Kelly being visited by the FBI for exercising her right, her political right to free speech. She cannot be deprived of that, her right to free speech, unless she's a citizen of the United States and a United States citizen. If she claims her right to free speech from God, she can exercise it. If she's claiming it as a citizen of the United States, it's gibberish. It's going to be taken from her. She's going to be regulated out of it. And I'm afraid people won't get this. When I say claim your rights as God-given, unalienable, claim your rights, if you're a Christian, claim them from your beliefs that that God's your creator. Claim your rights from there, because if you claim them from the government, you've lost them.
You're both right. People don't realize that citizen basically means slave. So if everybody in America believes that they are an American first and they are owed the Bill of Rights and they're correct when they're American, but when they've slipped into the citizen role, they're a slave of a corporation, and then the corporation only owes them partial privileges that almost correspond with rights.
But I think it goes to the fact that common law, the Bill of Rights is declaratory of the common law. You can look in American jurisprudence in the Constitution section. I think it's volume 16 of American jurisprudence, searchable online. I've got a quote here in this little book about Sir William Blackstone from the Blackstone Legal Fellowship. It says, the first thing we must understand is that common law is not civil law. It's not codified into tables and law books. Basically, they say it's the unwritten law. And what I understand is it's in direct conflict with civil law. So if you look at the Bill of Rights and you see that that's common law, as we start to get into, kind of the understanding that civil law is designed to control us, when we talk about the epic battle between freedom and control, maybe that's why we love the Bill of Rights so much, because it's about freedom. You go anytime.
What was that?
Go anytime.
So you said something interesting earlier about that if you use the Bible and God as your supreme law, then all of these other laws don't even apply to you. So what is the purpose of the Bill of Rights?
And that's kind of what they were saying at the Constitutional Convention. Why should we talk about our rights? The Constitution is about what we're allowing the state or the government to do. This has nothing to do with us, the people. So there was a big debate. Should we put these down? And I'm really glad they did, because these are things we totally agree with and rely on as a society, as a country. But really, the Ninth Amendment kind of says it all. You know, we retain all rights as long as we're not hurting our neighbor. You know, we retain everything. So just having these other 9 articles, it's redundant. They really are redundant. But what do Americans know about? They know about these. They know about the Second Amendment. They know about the First Amendment. They know to plead the Fifth, right?
That's really pretty much all people understand, I think. You know, the Second Amendment is their right to have a gun, which if you read it, it is actually it is the right for people to keep and bear arms. You know, so it's their right to have a gun. The first one is their freedom of speech, you know, which also, of course, includes assembly and petition. And then the fifth, people know of it if they go to court, you know, and they don't want to incriminate themselves. But it actually has a lot more involved in that than just incrimination.
Mm-hmm. Right.
So there's so much going on in these Bill of Rights that I think that it is a very valuable thing to discuss. It's written in a language that we don't necessarily use anymore. We don't use this type of language. So it can be confusing. You know, I look at the language of the ninth one that you just said. The enumeration in the Constitution, we don't use a word like that anymore, right? Numerical, so it's the numbers. So what does the word enumeration mean?
To just mark by a number. Oh, I'm sorry.
Right, to mark by a number in the Constitution, or the numbers in the Constitution of certain rights shall not be construed, right, or misrepresented or misconfused. Construed is to be confused with, right?
It means construction, the legal construction or lawful construction, meaning the laws written, how you write the laws. Mm-hmm.
So it shall not be written thus as, or written as, to deny or disparage others retained by the people. What does that mean?
Because we have this list of 10 rights in the Bill of Rights, you can't, this is the biggest one. Just because we're listing these, it doesn't mean including the following, excluding all else. It doesn't exclude all the others that we have. We have innumerable rights. You couldn't spend your whole life saying what all your rights are. So just because we've listed these 10 doesn't mean we don't have any others. We have all the others.
You know, it's really interesting. And why they put that before the 10th. Like, why isn't that the 10th Amendment? So the 10th one is the power not delegated to the United States by the Constitution. So to the United States being, this is before it was a corporation. So to the United States being that is the states in union. So the powers not delegated to the states in union by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people.
Yeah, and maybe I could give you an example that would make this one easy. Like the sheriffs, you know how Alaska doesn't have sheriffs?
Mhm.
Okay, so maybe it's not a great one, but let's just say that was a federal mandate. Okay. Actually,
I think what's confusing about this is that it's written in the negative. It's written in the negative. And so let's try to flip this around. So the powers not delegated nor prohibited by it. The powers not delegated to or prohibited by, nor prohibited by.
Right.
So the powers not prohibited.
Right. So the sheriff. Okay, Alaska doesn't have sheriffs, but it's not prohibited that we have a sheriff. So the right to have a sheriff is reserved to the people. So the people, the land jurisdiction people of Alaska, can appoint a sheriff. So this, you're right, though, it is a charter of, it's called the Charter of Negative Liberties. Where
What is?
The Bill of Rights, Charter of Negative Liberties, and the Constitution, really, for that matter. What they can't do, let's look at the First Amendment. Congress shall make no law. That's the Charter of Negative Liberties. Congress cannot make a law about the following.
I think that's what makes it difficult to understand as just a regular, we the people in our language that we use today, which has been so repulsively dumbed down to read. So basically what the 10th Amendment is saying is that the powers are reserved to the states or the people.
That's right.
And so if you take out all the negation, that's what the 10th Amendment says, is that the powers are reserved to the states or the people. And they are not delegated to the United States by the Constitution, nor prohibited by the United States by the Constitution. So I think that, because reading things in the negative is complicated, and I think that that's an easy way to understand some of this stuff, is to take out the negatives and kind of flip it around so you put it in the positive.
Mm-hmm. Yep, you can do that. And a lot of times when you're going into court and you're talking about what you believe, rather than making statements, you give negative averments. So this is, isn't it true that such and so, rather than making a statement that you have to prove, you just say, isn't it so that such and such. So having a charter of negative liberties is really important in our system, because it tells you the perspective of those writing this, that we are the creators and they're our creature, and what they shall and must not do. The way it actually comes down is, when we the people are telling the government shall or must, it's imperative. If they say to us, you shall or you must, it actually means you may or you might. Shall or must means may or might. When it's coming from, the government to you, Mindy, if they say you must have a vaccine, it actually legally should be construed as, you may want a vaccine, or you might think it's a good idea to have a vaccine. So this negative charter it's a really important part of the discussion, absolutely. And I think we ought to go through each one by one and just read them and kind of talk about what we notice in there.
I'm kind of into doing it backwards, because we've just talked about the 10th, and then
okay, cool.
And people are so accustomed to, everybody wants to get to the First Amendment. So let's do it backwards. So basically, the 10th Amendment says that the powers are reserved to the states or the people.
Mm-hmm. Okay. Yep, and that one, just one more thing to point out is, and this is all through Supreme Court decisions in the system, the states are the people, and the people are the states. Okay?
Right, because the people were divided into states, basically.
Yes, and then I wanted to bring up one other thing from our previous discussion about citizenship. There is a separate state citizenship. You can be a state national or a state citizen. As in contradistinction to being a citizen of the United States or a United States citizen. Those are two very different types of creatures. So just to kind of throw that out there for food for thought for now.
And just to clarify, you said the two things that are very different are being a state citizen versus a state national.
No, the contrast is between being a state citizen versus a citizen of the United States and a U.S. citizen. Those are there's two citizenships in the national in D.C. One is a territorial and the other is a municipal citizen. You have basically two national citizenships working against you, in my way of thinking. So let's just suffice it to say, being a state citizen is totally different than being a U.S. citizen. Let's keep going. Let's just keep going. I just want to put that food for thought out there for people, and we will refine that. We'll refine it as we go.
All right, so we got the Eighth Amendment, which is excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So I look at that as being that, that the bail, the fines, and the punishment need to be commensurate with the crime.
Right. Yeah, it's exactly related to that, and these new laws that have come out in the last few years talk about excessive bail being whatever bail is unaffordable to somebody who's being held in a local jail. If it's unaffordable to their family, it's excessive, and it can only be weighed against how dangerous that person being held, what a danger he poses to his family, to the society, to letting him go. So they've just recently reformed all of the criminal justice system to make the bails very, very 10% of what they used to be.
So it's a sliding scale.
It's definitely a sliding scale, and the judge in the case decides. Yeah, the magistrate, I should say. Yep.
All right. So we've got the seventh one, the Seventh Amendment, where it says in suits at common law, where the value is in controversy shall exceed $20. That a right of trial by jury shall be preserved. This is interesting to me. Of course, this is written, hundreds of years ago, and $20 was a lot of money. And now, $20 will barely buy you a meal.
Yeah, think of 20 silver dollars.
Well, right, but it doesn't say. But I understand what you're saying, but it doesn't say that. It says $20, right?
Well, but there is a definite definition of what a dollar is, and that's elsewhere in the Constitution as well. Federal Reserve notes are not dollars, but that's okay.
Well, I understand this, and you understand this, but I'm just reading this as it's written. But I understand, right?
Okay. Well,
and that the right of a trial by jury shall be preserved. So, in suits at common law. That's interesting phrasing. So, in a suit at common law, what does that word at is interesting there?
Yeah, it's my current and best understanding means that it's a civil case and not a criminal case. It has to do with contracts and not criminal. However, criminals also enjoy the right of trial by jury. It's just been preserved in every kind of a situation that you have the right to trial by jury.
Mhm. It's just one of those things where, now that we're looking at this and kind of going in depth with it, you see the words common law, and you, now that we've had all these conversations, our listeners would now understand that this is a total different jurisdiction than we would have if we actually went into our city, county, state, or federal court system.
That's right. That's right.
So,
and actually that civil system has a jury trial. The jury is only a panel. The magistrate decides the law. He gives the law to the jury, and even if the panel comes back with a not guilty or an innocent verdict, he can change it. That is different than a trial by jury.
mm-hmm.
And we can get into what that is. A trial by jury in a court of record, the jury is actually independent of the magistrate, and the magistrate merely acts as a referee. In the civil side, all the decisions are made by a lone actor of the state, and that's exactly why it serves to aggregate power instead of decentralized power.
This reminds me of growing up. We had Judge Wapner in the People's Court, and we loved that show. We watched that show every day. I mean, it was a family favorite,
Mm-hmm.
And then you see this guy that is just, he makes all of the decisions. So in that sort of a scenario, would that be things that don't exceed $20?
Well, no. What Judge Wapner was pretty good, apparently, according to a lot of people. He followed the rules all the time. But a trial by jury. What'd you say?
I said way better than Judge Judy.
Okay, yeah. Trial by jury is a right you can exercise, but you can also exercise the right to a bench trial. So you have the right to just have the judge decide. You don't have to choose a jury trial. Or a jury trial in the civil side, trial by jury, one of these courts of record trials by jury, we're finding out how to have them even in the civil courts, because they are preserved. They are underneath it all. They're hidden, and that's a really interesting discussion for another day, is how you get your court of record trial by jury.
Mm-hmm. Mm-hmm.
And so the second side, though, of the Seventh Amendment, in order to kind of get through all these today, no fact tried by a jury, and I look at this as a whole separate clause, separated by the word and.
Mm-hmm.
If there is a fact that's been tried by a jury anywhere in America, it can never be otherwise reexamined in any court of the United States than according to the rules of the common law. So it presumes that the facts are being tried by the jury in a trial by a jury in accordance with the underpinning law, which is our common law, which is really just a set of principles.
Be anxious for nothing, in everything, with prayer, supplication, and thanksgiving. Make your request known to God, it will bring peace that surpasses understanding. Peace that surpasses understanding. Guarding your heart and mind in Christ the King. Peace that surpasses understanding. Guarding your heart and mind in Christ the King. When the sea placid roils over with storm, there in the darkness your untroubled form gives me the most improbable thing. Peace that surpasses understanding. Peace that surpasses understanding.